All right, good morning, everyone. Welcome to the April docket of the Kansas Court of Appeals. We are conducting our hearings this morning by Zoom pursuant to our court's special COVID-19 rules. I thank the attorneys for participating in this procedure. I am Judge Thomas E. Malone. We also have Judge Gordon Atchison and Senior Judge Jim Burgess. We are the panel for the hearings this morning. We have 3 cases on the docket this morning. I'll call the cases in the order of the published docket. Just a few preliminary remarks to the attorneys. We have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. As the presiding judge, I'll be the timekeeper. Each party is given 15 minutes for your argument unless it's designated differently on the docket. And I don't believe we have any of those. If there's more than one attorney per side, you should let us know in advance how you're going to split your time. And the appellant's attorney should let us know at the beginning if you wish to reserve any of your time for rebuttal. After we hear the arguments this morning, your case will be deemed submitted for decision, and we will take the case under advisement and get a written opinion out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the first case on the docket. It is from Saline County. It's number 121-735. Entitled Loren Hopkins versus Great Plains Manufacturing Incorporated. And who do we have here for the appellant?
For the appellant, my name is Don Anderson. I'm from Wichita, Kansas.
And for the appellee?
Yes, Your Honor. I am Jacob Peterson on behalf of Great Plains Manufacturing, Inc. from Salina, Kansas.
All right, Mr. Anderson, do you wish to reserve any of your time for rebuttal?
I would like to, Your Honor. I'd like to reserve 3 minutes, please.
That is granted, and you can proceed whenever you're ready.
May it please the court, as you know, I am Don Anderson from Wichita, Kansas. I do represent the plaintiff appellant, Loren J. Jim Hopkins. This is an appeal from an entry of summary judgment from the Saline County District Court, dismissing his lawsuit on the grounds of the exclusive remedy rule of the Kansas Workers' Compensation Act, in that the exclusive remedy rule bars this action. In addition, the district court held that the application of the exclusive remedy rule under these circumstances did not violate plaintiff's right under Section 18 of the Kansas Bill of Rights. Those are the 2 issues before this court. Since the court is very familiar with the facts of this case, I won't delve very much into them other than to say that this is a case that involves a traumatic injury by way of accident that occurred on the job. Mr. Hopkins was a worker for the defendant Great Plains, and he was injured on September 5th of 2014. Mr. Hopkins suffered probably 2 injuries. The first injury being a myofascial injury that was described by the court-appointed expert, Dr. David Hufford, in the workers' compensation case. Myofascial means a strain or a bruise. So it's a relatively minor injury, but he did receive care as a result of that, going to the emergency room, follow-up care with the doctor, physical therapy. When the injury, the pain persisted, an MRI was ordered by the doctor, and that's where this case arises, because the MRI showed significant pre-existing degenerative disease throughout his spine. As a consequence of that, Mr. Hopkins realized that his employer was probably going to contest his injury. Therefore, he brought this workers' compensation claim. And as the court knows, the claim went through its entire process. It took nearly 4 years to come to its conclusion, but the conclusion was that the administrative law judge determined that Mr. Hopkins did not suffer an injury that arose out of the course and scope of his employment. Rather, it was a pre-existing condition. The ALJ found that the prevailing factor, which is crucial in this decision, the prevailing factor was the pre-existing condition and not the accident itself. Therefore, he suffered an injury that was not compensable under the Workers' Compensation Act. That decision by the ALJ was upheld by the Kansas Workers' Compensation Board of Appeals. They found the same thing, that he suffered a pre-existing condition and that the prevailing factor for his injury was that pre-existing condition and not the accident itself. Therefore, Mr. Hopkins suffered two injuries: a bruise that resulted in some treatment in which he incurred $9,619.06 and nothing else. He was awarded that, but it had already been paid. But he was awarded nothing else by the workers' compensation courts. He was not awarded permanent partial impairment. He was not awarded temporary total disability, anything of that sort, just past medical expenses. So the question becomes, in this case, whether or not he suffered an injury that was compensable under the Workers' Compensation Act. And the reason why that's important is because the exclusive remedy provision of the Act, KSA 44-501B sub D, specifically states, in pertinent part to this case, except as provided in the Workers' Compensation Act, no employer shall be liable for any injury by accident for which compensation is recoverable under the Workers' Compensation Act. So the key question in this case is, what does recoverable mean under these circumstances? Yes, Your Honor.
How is it that there are two independent injuries here? It seems to me you have a mechanism of injury that has multiple consequences, but why, as a matter of law, is it two injuries?
I say that there's two injuries because that's the way I believe Dr. Hufford characterized it in his report that was dated November of 2018 that he wrote specifically for this case. This was a traumatic injury where he was hit in the back by a forklift. That threw him to the floor of the warehouse where he was working. That resulted in immediate pain, severe pain, that caused him to be transported to the emergency room.
I understand the facts, and that's an injury for which he received compensation under the Workers' Compensation Act, correct?
It was a very temporary injury, but the compensation was the medical expenses. That is correct.
So how is the aggravation of his ongoing back problems a separate and distinct injury for purposes of the Workers' Compensation Act and the insulation of the employer from tort liability?
Because, as Dr. Hufford described, he suffered a physiological injury that resulted in an elevation or an aggravation of what he called an ambient level of pain in his spine. And that was aggravated as a result of that. That was separate from the bruise itself. Now, the two are connected because without the trauma that resulted in the bruise, he wouldn't have had the aggravation of the pre-existing condition. But nevertheless, that aggravation of the pre-existing condition is what persisted after that and persists to this very day, Your Honor. So we do believe it is a separate injury that is distinct. Does that answer His Honor's question?
Yes,
Thank you very much. So, and this is, of course, the injury for which he received no compensation. And that's the question in this case, is whether or not the exclusive remedy rule applies. And I've cited two cases, as this court is well aware. I've relied heavily upon the Andrews case, the Andrews v. Young case that arises or that was issued by this court. In addition to that, I've relied upon the unpublished opinion of the Logue versus Lane inliner case from the Federal District Court of Kansas. I understand that that's an unpublished opinion, Your Honors, and I'm well aware of that, but it was written by a very prominent and distinguished jurist. And I think the analysis of the Workers' Compensation Act under circumstances that were similar to this one is applicable, or at least very persuasive, or should be very persuasive to the outcome of this case. So according to Judge Milgren in that case, the defendant has the burden of proof to establish that the exclusive remedy rule actually applies to bar an action, the civil action such as this one. According to Judge Milgren in the Logue case, the defendant must show the existence of an employer-employee relationship between the plaintiff and the defendant, which is not an issue in this case. And then number two, that the defendant must show that the injury sustained by the plaintiff is recoverable under the Kansas Workers' Compensation Act. And in order to establish that, there must be a causal relationship that exists between the injury and the work involved, and that causal relationship exists between the conditions under which the work is required to be performed and the resulting accident. And then secondly, that the accident is the prevailing factor in causing the injury, medical condition, and resulting disability and impairment. The difference between Logue in this case is that Logue involved repetitive injury, whereas this one resulted in an aggravation of a pre-existing condition. In addition, as pointed out by the defendant, the difference between the Logue case and this one is that in Logue, you dealt with a motion to dismiss, whereas this one deals with a motion for summary judgment. While the two are different, the standards are very similar in the sense that all facts or allegations, depending upon the motion, must be drawn in the favor of the plaintiff as it exists in the case. So we believe that Logue is definitely persuasive in this regard. I think it's important to know that in the Logue case, Judge Milgren discusses recoverability. Again, he points out in that case, if the injury that is suffered, if the act does not provide for compensation, it's not recoverable under the act, then the plaintiff can bring a civil lawsuit in tort. And that's what exists.
Let me stop you here. I think the words you used are the key, and that is, are your client's injuries recoverable under the act? Isn't it correct that Mr. Hopkins would have fully recovered under his workers' compensation claim, including his current medical back issues and his claim for permanent impairment? He would have recovered for all that had the ALJ and the board simply adopted Dr. Fluter's opinion of his injuries as opposed to Dr. Estivo and Huffer.
Well, certainly that's a possibility, but that's not what occurred in this case, and that's not.
Well, I know that, but it seems like he could have recovered. He just failed to meet his burden, at least according to the ALJ and the board, based upon the facts as they found them to be.
The KSA,
if they would have believed Dr. Fluter and adopted his testimony, it seems like your client would have fully recovered all of his claims under the Workers' Compensation Act. Therefore, there is recovery under the act.
but as this court pointed out in the Johnson case, it just simply wasn't possible because he suffered an aggravation of a pre-existing condition. And as his honor knows, KSA 44508F, I believe it's 2, specifically states that there's no compensation for an injury that is solely an aggravation of a pre-existing condition. So there's no way that he could possibly recover under this particular act. I mean, the LJ did find that prevailing factor was
if you show that the injury is the prevailing cause of the aggravation, there still can be some recovery there. Isn't that correct?
I don't believe so, but because again, the statute is very specific. It specifically states there shall be no compensation for an injury that solely results in an aggravation of a pre-existing condition, which is what we have here. I mean, we have that here, and that's what the statute
the word
provides.
solely would have some meaning in that, wouldn't it?
possibly does, but the reality of the circumstance is there's always going to be some type of a bruise or an immediate pain associated with a traumatic injury, which is what we have here. But that's not the injury that we're talking about. The injury that we're talking about here is an aggravation of a pre-existing condition. And that, I believe, is the critical thing, because the Workers' Compensation Act does not provide for compensation for such an injury. The Johnson Court pointed that out. In 2011, they did away with that. Before 2011, he could have received compensation for it, but the legislature did away with it in 2011. So I mean, that's the position of the Court of Appeals in an earlier case. Now, of course, that opinion was reversed on other grounds, but nevertheless, I think that analysis is absolutely correct and is borne out by the history of the changes to the Workers' Compensation Act.
You're moving into your rebuttal time. You've used 12 minutes of it. You can continue if you want.
I believe that this case can be decided on the first issue and should be decided on this, that issue. But if not, then he's been denied a remedy. He's suffered a substantial injury, which I pointed out through the facts in this case. And this is a very serious injury that was life-altering, and he hasn't received a remedy for it. He hasn't received one penny. So with that, I will preserve the remaining part of my time for rebuttal. Thank you, Your Honor.
Thank you. Mr. Peterson.
Thank you, Your Honor. May it please the court and counsel. Plaintiff's exclusive and constitutional recourse for the harm he suffered at work is under the Workers' Compensation Act. But as the court pointed out in their questions with counsel, the unfortunate thing for Mr. Hopkins is he didn't meet his burden of proof. He wasn't able to prove that the harm he's claiming now was the prevailing factor under the Workers' Compensation Act. Now, after the ALJ did indeed give the plaintiff an award, he's asking this court to give him a second bite at the apple to get the compensation he was seeking. But there is nothing under the act, the bargain that act effectuates, or Section 18 of the Kansas Constitution that guarantees anybody compensation for what they're seeking. And plaintiff indeed is not and has never been guaranteed to receive the compensation he was seeking under the act. And I think the court in the questioning for the plaintiff really touched on the distinction here between plaintiff's counsels and our position. And that relates to the difference between the scope of coverage for the Workers' Compensation Act and the outcome under that act. Plaintiff is, and as plaintiff readily admits, plaintiff believes that he must receive the compensation for permanent disability that he was seeking under the act, or the exclusive remedy provision doesn't apply. And that's simply not how the act works, and it's not how the exclusive remedy provision works. And as a practical matter, we can look to the act's notice provisions, which have been in place for decades and have denied claims for decades, but tort claimants have never been subject to that. If plaintiff's construction of the Workers' Compensation Act was true, those claimants who had their claims denied on the basis of those notice provisions would have been able to turn around and sue their employer in tort. That doesn't happen. That didn't happen, and it's not allowed to happen under the act. But drilling down to the exclusive remedy provision, it discusses how no employer shall be liable for any injury for which compensation is recoverable. And Judge Malone, I believe you just touched on this distinction in your question to counsel relating to recoverability. And that's important because the court's correct. Plaintiff could have recovered under the act. This is a forklift to person collision at a manufacturing plant. That is a classic workers' compensation scenario. And plaintiff was able to present expert testimony indicating that indeed that collision was the prevailing factor in the disability that Mr. Hopkins is now claiming. The problem for the plaintiff is that the ALJ wasn't ultimately convinced by that. Plaintiff had the opportunity to take his case to the ALJ and the Workers' Compensation Appeals Board, for that matter, on the merits and present evidence that would have allowed them to recover under the Act. But the ALJ, as the fact finder, as many fact finders have to do, had to make a choice and had to make a decision on which testimony was the most convincing.
Well, counsel, would you at least agree that the 2011 amendments to the Act, and specifically the new prevailing factor test that's been put in there, would you agree that that at least makes it more difficult for an injured worker to recover for an aggravation of pre-existing injuries?
I would agree, Your Honor, and I don't think anybody's disputing that. We readily admit that those 2011 amendments were meant to and designed to address rising workers' compensation insurance costs. And a part of that was the prevailing factor standard, which increases the causation burden on claimants. But the crucial thing to remember relating to the prevailing factor standard is that the fundamental bargain at the core of the Workers' Compensation Act is still a good one. Those benefits that workers receive are still significant under the Act. And this case is a perfect illustration of that. Here, well, let me take a step back. Under the Act, the fundamental bargain, of course, is that workers can make claims without having to prove negligence and receive somewhat more limited damages under those workers' compensation claims. And the employers, on the other hand, agree to compensate for those claims where the claimant may not be able to show negligence in exchange for more limited damages. In this case, as we've indicated, Mr. Hopkins, there's evidence that Mr. Hopkins may have indeed stepped in front of the forklift that collided with him. And also that one of his co-employees was driving that forklift. Now, rest assured, if this case is reversed and remanded, Great Plains Manufacturing will put on that kind of comparative fault, fellow servant doctrine evidence to try to prevent Mr. Hopkins' recovery at the trial court level. But
I don't know that it matters here, but the fellow servant doctrine has been abrogated in Kansas, hasn't it, by the Kansas Supreme Court?
I don't believe so, Judge. I believe it is still indeed viable, and we intend to bring that up. But the broader point is that they don't have to contend with negligence. And the comparative fault doctrine certainly speaks to the idea that we can put on evidence that Mr. Hopkins was at fault for his injuries. He didn't have to worry about that in the workers' compensation proceedings because it's frankly irrelevant to those proceedings. Whereas he will have to tangle with those things and could receive absolutely nothing. Mr. Hopkins received a much better chance at recovery under the Act than he will under any kind of a civil tort proceeding. And that is a real and substantial benefit that is still afforded to him, regardless of that increased compensation burden that Judge Malone pointed out before. Now, turning back to the exclusive remedy provision, there's also an additional absurdity associated with plaintiff's view that he must receive compensation under the Act. And that is that it disincentivizes vigorous employer defense and vigorous employer response to those workers' compensation claims. And this case, again, serves as a perfect example of that. The Great Plains Manufacturing responded to the claimant's claims, got an expert to respond to those prevailing factor allegations, and indeed the Workers' Compensation Court got an IME physician to render an additional opinion, obtained a favorable result on the merits, and is now rewarded with a civil tort suit because they were successful in the Workers' Compensation Court. That disincentivizes vigorous employer defense, and that's simply an absurd result. And not only that, but it is also inconsistent with the obvious purposes of the 2011 revisions, which were to decrease employer insurance costs associated with the Workers' Compensation Act. It's obviously going to raise employer coverage costs if they have to turn around and face civil tort suits, or if they have to simply lie down and submit to the Workers' Compensation Act so that they can avoid having uncapped liability in a civil tort suit. Employers should not be rewarded for fighting themselves out of the frying pan by being thrown into the fire of a civil tort suit. That's simply absurd. Now, in addition, as we talked about and as plaintiff's counsel discussed at the very end of his argument, there's also the Section 18 challenge associated with this case. And that obviously applies if the court agrees with Great Plains that the exclusive remedy provision applies to this case. Then plaintiff indicates that indeed there is a right to remedy violation because he wasn't able to recover the compensation he was seeking under the Workers' Compensation Act and isn't able to recover that compensation he was seeking under under a civil tort suit. But that's a false dichotomy. Nothing in Section 18 guarantees that plaintiff will receive what he was seeking. And indeed, as the court pointed out, plaintiff received an award by the ALJ for those past medical expenses. He received compensation under the Workers' Compensation Act itself. It just wasn't the compensation that he wanted. And as we discussed before, there's this fundamental bargain under the Act between employees and employers, and fittingly.
Well, you refer to that in your brief. That's not really correct. I mean, Mr. Hopkins didn't bargain for this. I mean, it was the law that was imposed on him and he didn't have any choice. I mean, it's a social policy decision made by the legislature. It's not a bargain between an employee and his employer, is it?
Well, you're correct, Your Honor, that Mr. Hopkins didn't engage in negotiations with his employer. But that is most certainly the concept under the Act and the justification for why this is permissible under Section 18. Section 18, the test for compliance with it after it applies, is based on the concept of a bargain. To the extent that common law rights are abrogated or removed, there has to be an adequate quid pro quo. This for that. And that's exactly why the Workers' Compensation Act is permissible under Section 18, because there is this exchange. And maybe perhaps bargain is not the correct terminology, but there's certainly an exchange, a give and take between employers and employees that indeed the legislature has chosen to implement. But there is an exchange of rights that supports and is fundamental to the Workers' Compensation Act. Does that answer your question, Your Honor?
Well, you just make an argument, particularly in the brief, and are repeating it here, that it makes it sound like there's some choice involved between the employee and the employer, and that's simply not true. It's a public policy decision, and it may be a valid one, but to suggest somehow that it's a bargain that Mr. Hopkins voluntarily entered into and therefore he should lose is mistaken.
Your Honor, I'd agree that it's correct that Mr. Hopkins did not choose to be subject to the Act. So I would certainly agree with that. Our point in the brief and in this argument is merely that exchange. And that exchange is especially important to Section 18 for the reasons that we talked about before, that quid pro quo. And as we've identified, that quid pro quo in this case is a very significant one, especially for the reasons that we've identified, that we don't have to tangle with comparative fault or perhaps the fellow servant doctrine as we discussed before. But
you have 2 minutes.
Thank you, Your Honor. There is nothing under Section 18, however, just like there's nothing under the Act that guarantees that plaintiff will receive the compensation he's seeking. Plaintiff had the opportunity to recover the compensation he sought under the Act. He had evidence that would support the compensation he was seeking under the Act. The problem is that the ALJ and the Workers' Compensation Appeals Board simply were not convinced by the plaintiff's evidence. And simply because the plaintiff was not able to make his case doesn't allow him to now turn around and get a sort of secondary appeal in this civil case in tort. That's not what the Act provides. That's not what Section 18 provides. And indeed, the Act itself forecloses this action by virtue of the exclusive remedy provision. Are there any other questions from the court? Okay.
Apparently not.
Thank you very much for your time, Your Honors.
Thank you, counsel. Mr. Anderson, you still have your rebuttal.
You've muted yourself.
Thank
There we
you
go.
very much, Your Honor. I'm just not used to this Zoom technology. I apologize. There is one thing that I wanted to point out with respect to this issue about whether or not the plaintiff lost at the workers' compensation level and then trying to get a second bite at the apple or an appeal. In the Logue decision, we must remember that the plaintiff in that case first filed a workers' compensation claim before he filed his civil tort action. And that workers' compensation claim was denied on the basis that his repetitive trauma was not the prevailing factor causing his injuries. While we're not dealing with repetitive trauma, we're dealing with an aggravation of a pre-existing condition. Certainly, the findings are similar in that case in the underlying workers' compensation case with what we have here. So I just want to point out that similarity between the Logue decision as well as this particular case too. In addition, the findings of the Court of Appeals in Indris, I think, are interesting as well. One of the things that the court pointed out there is that the plaintiffs contended that Mr. Indris had a pre-existing coronary condition. Then it states, if the facts developed that Indris' heart attack was indeed solely an aggravation, acceleration, or exacerbation of his pre-existing condition, then the plaintiff's claim would be excluded under the Act and he could proceed with a civil tort action. So I believe that there's similarity there. Just want to touch briefly upon the constitutional arguments. Just want to point out a few things. Number one, in spite of the decision by the Kansas Supreme Court in Johnson, I do believe that the Pardo decision survives. In the Pardo case, the Court of Appeals dealt with a statute that required application of the 6th edition of the AMA guidelines. It was mandated under that statute. That statute was different than what we're dealing with here in this case, or at least in the case of the Johnson, case. And so I think the Pardo analysis is a good analysis. And I also want to point out too that the Johnson case did not criticize the analysis of the Court of Appeals on its constitutional findings and holdings. Rather, it just said that it necessarily fails under the circumstances of that case because of its interpretation of the statute.
Counsel, I think I understand your Section 18 argument, but I'm not sure about the remedy you're seeking. If you prevail on your constitutional claim here, what exactly are you asking our court to do in terms of a remedy? Are you asking us to strike the exclusive remedy provision as being unconstitutional, or what exactly are you asking for in terms of a remedy?
I thought that you might ask that question, and I've given that some thought. I think that the court, if it so chooses, should hold in this particular case that the application of the exclusive remedy rule violates Section 18 under the facts and circumstances of this particular case and leave it at that. If it needs to do more than that, then I believe it should follow what the Pardo court did, and that is to strike the pertinent portions of the statute, which is listed under KSA 44508. That deals with excluding all compensation for pre-existing conditions, as well as excluding them under the prevailing factor standard. So those can be written out of that statute if that's what the court so chooses. But I would just recommend that you hold under the facts and circumstances of this case that the application of the exclusive remedy rule is unconstitutional and remand for further proceedings. Does that answer your question?
If there's any further questions. Apparently not. So counsel, I thank you both for your briefs and your arguments. It's an interesting case. You both did a very good job. As I indicated, we'll take the matter under advisement, get a written decision out to you and your clients just as soon as we can. And so with that, this hearing